Greetings, my name is James Bell of the law office of James A. Bell, PC. This discussion will involve the various levels of proof necessary to convict you in a criminal case. And if all of these levels of proof are not met, then you should be found not guilty. A crime is composed of elements, that is, parts. A good example is first-degree murder. It has willful, deliberate killing of another with premeditation and malice aforethought. Each one of those are elements, and it must be proven beyond a reasonable doubt. At the bottom of the evidence of the chart, if there is no evidence, one will be found not guilty if there was no trace of evidence whatsoever. If there was a scintilla of evidence, a suspicion or a hunch, any evidence at all, even the smallest measurable amount of evidence, you would be found not guilty. If there was reasonable suspicion, you should be found not guilty. It should be based on specific or particular facts or reasons, but it shouldn't be based on hunches or guesses. The next step would be the probable cause. That is the level by which the officer has to take you into custody, to seize your person, to bring you before the bar of justice. If there is only probable cause shown, that will get your case bound over to the grand jury, but it is not enough to make you be judged guilty in a court of law. It must be based on reasonable and trustworthy information that a particular person has committed a particular crime in a particular jurisdiction. The preponderance of the evidence step. You go up the steps, and these are the stair steps. A person who has been shown to have evidence, more likely than not, is still not guilty. That's the greater weight or the amount of the evidence. It's not who do you believe, it's whether or not you believe the state's witnesses beyond a reasonable doubt. The preponderance of the evidence standard is that standard which we find in civil cases, that is, where the juries return a verdict of money judgment against you. The next step is clear and convincing evidence. If the evidence rises to that level, you're still not guilty. That's a firm belief that the allegations are true. When the evidence is clear and convincing, that is the sufficiency of the evidence, for example, for the state to take your children away from you on allegations of harm. Reasonable doubt. If from all the proof there are reasons, reasonable reasons, doubt reasons, things that would make you hesitate in the normal course of your life. If the evidence raises reasonable doubt, then you should be acquitted or found not guilty. To get to this level of guilt, the proof requires you to be found guilty of other facts beyond a reasonable doubt and up to that level. This is a chart that we use in jury selection and have used it for years very successfully. Sometimes we use it in a PowerPoint presentation. Oftentimes we use just the enlargement chart as here. Thank you very much. If you have any questions, please contact the office at 865-637-2900.